Okay, looks like I'm live. I'm going to be posting the link over at Parler. Over at Parler is where I'm going to be taking questions today. So I'm going to mute myself here. There we go. Okay, so I'm waiting for Eugene to show up. And in the meantime, like I said, I'm going to post this link over at Parler. Okay, we are all set. And so now I do wait for Eugene. Let's see if I have some people joining me over on YouTube. Okay, I got 3 of you watching. Yeah, so we are all waiting for him right now. Let's see here. Okay, let me get back over and see. How are you guys doing over at Parler? Let me see if I've got any comments. You guys can start leaving questions for him here on this thread if you're watching. I know maybe some people are joining me over at YouTube, but the place to post questions is over at Parler. Okay, it looks like Eugene is here. Going to let him in. Hello, Eugene.
Hey, Amy, how are you?
I'm doing well. Can you hear me okay? I guess you can, right?
Yes, but actually, let me plug in my my little earpods. And you know, I just realized I probably should pull up again the text of the proposed change, statutory change that you are that you mentioned you wanted to talk about. Are we going to get into the textual details? Should I have it on the screen in front of me, or?
Yeah, you can get it on the screen in front of you. It is mercifully short.
I'm sorry, I will. It is what?
It's mercifully short, so that if you're doing it on the fly, I don't think it's going to be too much, but also I will summarize for you the sorts of questions that I have. I don't know if you've read it before or not.
Yes, I have, but I don't have the text. I don't have the link handy.
Okay.
So,
okay.
so just give me a moment.
Of course, of course. We also, it looks like we're having trouble with the connection a bit.
Yeah, you know, you do sound kind of weirdly tinny.
Okay, and I'm not sure if it's mine or yours, and I'm going to ask for some feedback from some people who are watching. I'm not sure how your connection is there. Have you had trouble with your connection there before?
No, my connection has been great.
Okay.
At least generally.
I hadn't either. Yeah, I'm not sure why we're having the.
Let's just move forward right now.
Okay, that's fine. We'll try.
Although, yeah, you know, I have to say your beginning to fade in and out.
Okay. Well, do you want to disconnect and reconnect? And I'm going to look over on YouTube and see what it looks like.
Sure.
Let me see what I'm getting over.
Let me disconnect and reconnect.
Sure. Yeah, mine seems smooth.
Okay.
Okay, great. Okay, so he's off and he'll come back on again. And I'm going to mute YouTube again so I don't get confused by the feedback, which is about, I don't know, 6-7 seconds behind, something like that. See if we can get a better connection here. I think you guys are hearing me okay, right? If you guys are watching and you want to just let me know if it sounds smooth, at least me on YouTube. See if I can do anything at all, get any device off of Wi-Fi. Not that it should. I've got a hardwired connection here, so it should be fine. Wait for him to get back in. Okay, there he is. Let's hope. Okay.
All right, I am here. Sorry for the technical mix-up, but you sound better.
Okay, well, that's good. That's good. And as far as I could tell, I was sounding good.
Great. So,
well, thank you. I will take compliments, but I think Zoom does us a little bit of a service here. I think Zoom makes us look slightly more attractive, sort of like an Instagram filter out there. Now I'm not hearing you, though.
Really?
Okay, now I hear you.
Okay. All right. Technology.
It's, yeah, glitchy. So speaking of, so first of all, I should introduce you, of course. So this is Eugene Volokh, everyone. In case you've been under a rock forever and don't know him, he is a renowned professor at UCLA Law School. He had been a clerk for Judge Alex Kozinski of the Ninth Circuit, which is how I met Eugene, because I was an intern for Alex Kozinski many, many years ago. So many years I shouldn't talk about how many. And he also clerked for Sandra Day O'Connor, is that right?
I did.
Yes. And before that, even, you were a successful software entrepreneur before you even went into a law career. Am I right about that as well?
This is true. For 12 years, I was a computer guy.
And are you still a partner? Because that's still in your bio everywhere. Are you a partner in a software firm?
Yes, but the computer that for which our software was prepared is largely out of action now. So it's really I do very little with it, and we do very little. We still have some customers.
Okay, so you are just continuing to provide service for the customers like a very good ethical businessman, basically.
We try.
Okay, excellent. And then in addition to that, you have long ago, I forget how long ago, that you started the Volokh Conspiracy Blog, which is a well-known blog of legal scholars, mostly libertarian. How long ago was this?
We started in the spring of 2002, so we're going on 20 years now.
That's excellent. And so at first you were just freestanding solo blog, and then for a while it was hosted by Washington Post, right?
Exactly.
And now you're over at Reason?
And now we're at Reason Magazine, yes.
Okay, well, excellent. And how are you doing in the COVID? You did okay? I haven't kept up with you that much.
We're very fortunate. My wife and I both have jobs we can do remotely. I'm on sabbatical this semester, so I don't even have. My students are at a school which does a pretty good job of teaching remotely. My kids are at school. They're 15 and 16, so they're actually not that hard to manage at home.
Okay.
So we're surviving, and knock wood, we've been very lucky.
Okay, well, I'm happy for you. That goes into sort of my next general question. You know, 2020 has been a nutty year with the COVID, but then also this election, because you're on sabbatical and maybe because you've been working from home, you're a little more isolated from this. But I was going to try to get your sense among students, law students, and also maybe your colleagues about this election. Has it been very divided and acrimonious and political like I see out there in the world of social media, or not so much?
You know, I've actually interacted relatively little to with my colleagues and students outside of class or faculty meetings because of the epidemic. In a normal year, I would have been in the building. I would have had lunch with people, or run into people in the hallways. That's actually something that could still be arranged by institutions. You know, I think at some point when people do more remote work, they'll set things up so that everybody's supposed to spend 15 minutes just hanging out with each other and drinking coffee online. But right now, the interactions I've had with students and colleagues have been almost exclusively, I'm teaching a class, or we're editing a brief together, or we're in a faculty meeting, and there the politics doesn't come up. My sense is it's probably extremely acrimonious, both because of how acrimonious universities have gotten generally, and how acrimonious political life has gotten generally, and how divided or how far apart in so many ways the particular candidates are. But I've managed to ignore most of that, except what I see online. And there I see what I choose to see.
And so that was a question that I had in terms of social media. You recently did just join Parler via the Volokh Conspiracy only, though. Personally, you're not very involved in social media. Is that right?
Yes, absolutely. I have a Twitter feed, and it's almost exclusively, probably 99.9%, automatic feed from my weblog. I have a Facebook page, but likewise, my personal page I never really check, and for the blog page, it's all automatically fed through our RSS feed. And that's for a combination of two reasons. One is if there's something I really want to say, I'm probably going to say it on the blog, because why only say it on Twitter? And second, the things I want to say are usually not a couple of sentences. It's rare that there are a couple of sentences that are really good enough, important enough that they are worth saying. And again, if they are, then why not say it on the blog as well? So I've always preferred kind of the medium length writing that blog posts offer, more than the 140 characters of the old Twitter. I guess it's 280 now, or the longer, but still limited space that Parler provides.
Yes, we have 1,000 characters, so it's quite generous, but still probably shorter than the medium length blog posts that you have in mind.
And again, if I have 1,000 characters worth of something to say, why not say it on the blog and then have it automatically show up in Parler?
Okay. So you're over at Parler primarily to share what you are writing in the format that you find ideal. So you're going to share it with the Parler users. And I've seen you do some interaction over there as well in terms of sort of, I forget what the appropriate term that I used to have for it was. It's not babysitting, but it's, you know, sort of sending out into the world your little bits of writing and contribution, not just from you, but from your colleagues. You have a number of very great minds working with you at the Volokh Conspiracy. So it's not just you by a long shot, right?
Right. And I'm very glad about my co-bloggers. They have a lot of things to say on subjects that I don't know enough about, or I'm not interested enough in. And I'm very glad that they're writing. One thing I do want to stress for Parler readers is we are a group blog. So just because something comes up on the Volokh Conspiracy doesn't mean that it is from me. So when you see a particular post, if you want to know whom it's written by, just click on the post to go to our webpage, and then you see, of course, I'm sorry, if you see a headline, that's really all you see on Parler. If you see a headline and you want to know who wrote it, click on it, and then you see the rest of the post, and you see the author's name. But don't just assume that it's all from me, because much of it is from my cherished colleagues and co-bloggers.
Yes, yes. So there's one more sort of in the air subject that can't be ignored thing that I have to ask you about, and that is Ruth Bader Ginsburg. I gather from one brief post on the Volokh conspiracy that I read from you that you did not know her personally, but how are you affected by her passing last week?
Well, she's one of the titans of my chosen profession. If you look at lawyers, who are the lawyers who are best known and who are often the most illustrious, she would be on any such list. So I had very great respect for her. I only met her, I think, once, but I've certainly followed her work very closely. And she really had a remarkable career as a very successful lawyer, champion of women's rights. That was her main field. She argued before the Supreme Court and litigated many cases, as a successful professor, as a very well-regarded and I think admired by both sides of the aisle federal appellate judge on the DC Circuit for 15 years before she joined the U.S. Supreme Court, and then as a Supreme Court justice. So she was a remarkable person, and there's no doubt that all that she did was made particularly difficult for her, especially early in her career, by her being a woman. There have been women in American law since late 1800s, but especially early 1900s. There was always a smattering, not always, but since then there'd been a smattering. For example, the first state Supreme Court justice was a woman, was in Ohio in the 1920s. There have been federal appellate judges as well since the mid 1900s. But it was very rare and very difficult and took a lot of guts, took a lot of drive to do that and to succeed. And she did. And likewise, when she became a law professor in the 1960s, it was very rare to see women law professors. Right. Some, but a lot fewer. So I very much admire her. I agreed with some of her opinions, disagreed with others. Probably on the controversial matters, I disagreed with her more than I agreed with her. But I very much admired her work and her personally.
And do you take a position on should he fill the seat or not? The big controversy that everybody's talking about.
You know, to me, this is not a question of high constitutional law, certainly constitutional law or high constitutional principle. The president indubitably has the authority to nominate a candidate, whether it is right before an election or even after an election, that if he loses, even if he's a lame duck, he has the authority to do that. And the Senate has the authority to say A or nay. So in 2016, President Obama nominated Merrick Garland, which he had every right to do under the Constitution. And then this Republican-controlled Senate declined to even hold hearings on him, which it had every constitutional right to do. And it also, as a matter of kind of ethical principles, I don't really see much of an issue here. But as a matter of good judgment, and especially in light of the political factors, there are very interesting questions here. So, for example, the Democrats are threatening that if somebody is appointed to the court before the election or after the election, if President Trump loses, then if they win the presidency and they win the Senate, which seems not certain by any means, but certainly possible, they will pack the court. They will add more justices, which they're also constitutionally empowered to do. The U.S. Constitution doesn't say 9 justices. It's a matter of statute, and the number of justices has changed over time. It was 6 at the time of the first Supreme Court. Now it's 9. At one point it was 10, so they'd be able to do that. So one question is, to what extent do we want to avoid that? And if we want to avoid that, would it be better not for the Senate and the president not to exercise their power now in order to avoid that? Although the flip side might be, even if the president and the Senate don't appoint a or don't place a new justice on the court. The president appoints, the Senate confirms. Maybe even if they don't do that, maybe the Democrats will still pack the Supreme Court. It's possible. So those are the questions that I don't have an answer to.
Here's one. So if the seat remains vacant and there's a repeat of Bush versus Gore of 2000, and everything goes all the way up to the Supreme Court, and then we have a 4-4 in the Supreme Court, how will that be resolved? And do you think it would be better for it to be resolved that way versus, say, a Trump-appointed justice, a new Trump-appointed justice as the tiebreaker?
Well, there is a legal answer to that question. When the court divides 4-4, then the decision of the lower court stands.
Right.
There's almost always a lower court decision, and that is the result. It doesn't set a precedent for the future, but but that's the result, and there's no controversy that is the result. Now, you might say, well, but will that be seen as fully legitimate? Because among other things, it means the decision is by a bunch of, let's say, state Supreme Court justices or just judges who happen to be in a particular 3-judge panel
well, it could be an en banc decision at least, right?
It could be. It could be. Most decisions are not en banc, especially.
No, I know.
Most hurried decisions are not en banc, because this is all going to be, if there is going to be litigation over the election, it's going to be pretty quick. So in any event, it could be en banc, and in the Ninth Circuit, it's not even the whole court, it's just 11 judges. So you might say, isn't it better, it would be more definitively resolved by the Supreme Court? But from the perspective of legitimacy before the public, it's not clear whether a Supreme Court, which is 5-4, in part because of this fifth judge being appointed by, fifth justice being appointed by the president and confirmed by the Senate in these just the coming basically month and change, that's going to come across as more legitimate to the country than the court dividing 4-4 and then some lower court decision by some unknown judges being affirmed that way. I don't know. I'm not talking about what should be seen as more or less legitimate, but as a matter, how can I predict that? I didn't predict the 2016 election. I was badly wrong in that. I was badly wrong in the nomination. My track record of trying to predict the reactions of my fellow citizens is appalling. So why should I claim to know, oh yes, obviously it's going to ruin the court's legitimacy? What do I know about such things? The other thing, of course, is the court right now is not 4-4 Republican and Democrat appointed, to use kind of very rough proxy, not 4-4 conservative liberal, it's 5-3 conservative liberal. And while some of the justices in the majority sometimes join the minority and vice versa, it may be that it's not going to split 4-4 in any case. But it's true, it would have been really bad if there were no rule that says what happens when there's a 4-4 decision. That would have been really bad, because then people say, my God, there's not even a judgment in this case, setting aside whether there's a precedent. But fortunately, such a rule. There was a line, I think, from Justice Brandeis back in the day, which is, for some questions, it is more important that the rule be settled than it to be settled right. And that's especially true for procedural issues. Like, we need to know what happens when there's a 4-4 split. It could be flip a coin. Maybe that's not optimal, but maybe not. Well, why not?
Right.
But we just need to know. There needs to be a rule. Not for everything, but for some things, that's what's really important.
I'm not a huge fan of Brandeis because of his role in creating the so-called right to privacy, which is something I talked to you about decades ago. But there, I think he's got something right.
And some good, some bad. He was pretty good on free speech.
Yeah, he had some.
A few who was good on free speech back then.
So that would make you particularly attached to him, because free speech, of course, is.
I try not to be particularly attached to people. People disappoint you. Disappoint you. Right? This is part of the problem, I think, with a lot of the controversy about the iconoclasm of recent years. Like, I don't believe in tearing down the Washington Monument or the Jefferson Memorial or various other things. But I do think it's a mistake to try to idolize Jefferson, Washington, whoever else. Forget even about the slavery stuff. They were people. They were human beings. Not only that, they were a particular kind of human being, which is known as a politician. And while there are some politicians that we think are more honorable than others, all of them have to go through the messy sausage-making business of politics. And all of them, in order to have risen to that level, have had to do all sorts of things that they may have found to be personally quite obnoxious and quite wrong even, and maybe, or at least should have done that. So you know, I think they should be appreciated for what they did, but nobody should try to make a saint out of a president or a justice or a general or whoever else.
Yes. Just
We're
as
not
much as
saints.
ad
Why should they
hominem
be
is a
saints?
fallacy, right? Just as much as ad hominem is a fallacy. We look at the substance of what they have to offer. Okay, I like it. With respect to the justices, are you familiar with the trolley problem in philosophy?
So I'm sorry, is the question if you are on a trolley and there's a justice standing in front?
No.
The question is
so
whether you should take this trolley, if there's Justice Scalia is in front of you and Justice Ginsburg is, I don't understand the connection.
Okay, so what I'm saying is there's a trolley problem right now that basically Trump can decide whether or not to appoint a justice. And it looks like the result could be bad either way in terms of legitimacy of the court. And so maybe the best solution is not to purposefully steer the trolley in one direction or the other. But if this is if you're not familiar with the trolley problem in philosophy, I'll send you a link later and you can geek out with me another time.
Well, no.
Okay?
I was trying to convey that I am familiar with the problem, but just didn't see it applied to justices.
Okay. I come up with weird analogies. It's part of what I do.
And it's an interesting problem because part of the question there is there something especially meritorious about inaction? Or at least if not meritorious, at least especially morally less culpable. That maybe if we have a choice between two very bad things, one thing happening as a part of our effect with our actual affirmative decision, and one, if we just let things go on, we should just let things go on because then we're less culpable. I'm not sure that is true as to government officials whom we hire specifically to solve problems. So if somebody says, well, you know, if I bomb this country, then this bad thing happens. If I don't bomb this country, that bad thing happens, I'll just do nothing. I'll say, well, it's not your job to do nothing. It's your job to do the best for us, either as a country or as a world or whatever, however way you want to define it. I generally think the best for us as Americans, or subject to some moral constraints. And inaction does not give you any special moral dispensation. But especially here, everything that the president does is plausibly seen, it seems to me, as effectively an action here. So I think the trolley problem is very interesting, and there are particularly interesting questions that used to be an interesting philosophy problem, but now it becomes a practical problem of ethics in computer programming. Because when you have self-driving trolleys, you actually have to program the trolley to make that kind of decision.
No.
Right.
Don't go there.
Right. And this is the classic problem, by the way, with self-driving cars in exotic context, which is that do you prioritize the life of the driver because it's his car and he's your customer and therefore you have a special duty to him, or do you prioritize the life of, let's say, the pedestrian who's crossing the street, and the question is swerve to avoid him? And you even have the probabilities there, like the chances of the pedestrian dying are this much if you hit him, but the chances of the driver dying are that much. What if the driver has 3 passengers? You actually have to code this stuff. So it's turning from a theoretical question into very practical.
Okay, you definitely saw my trolley problem invocation and raised me by a lot. So let's go on to strictly law again, and then That's I can good. Ask you, and you can be the expert. I wanted to talk with you about Section 230 because, as a person who is now working for Parler in policy, I have been concerned with Section 230 in general. I have heard, or I believe read somewhere, that you believe that Section 230, as it's currently written, gives very wide latitude to social media platforms in terms of figuring out what their community guidelines would be, what sorts of content should be taken down from the platforms, etc. And am I right on that? First of all, I was never your student, but I'm getting a test now, right?
Let me answer unambiguously. Yes and no.
Okay.
So Section 230 has two main portions to it. I'm not talking about specific sections, but two main conceptual portions. One is, and this is the most important one, is that platforms are immunized, generally speaking, from liability for posts by third parties, usually by their users. This is an oversimplification, but it's tremendously important because there are all sorts of bodies of law that might hold a platform liable. Let's say, for example, somebody posts something defamatory on Parler. Absent Section 230, it would be a very plausible argument that if Parler leaves it up, especially once they're put on notice that this is supposedly defamatory, and of course they don't know if it's defamatory, but it's been accused of being defamatory. If they keep it up, absent Section 230, they could very well be liable. And what that means is either Parler and Twitter and Facebook that just can't exist. Or if they do exist, they have to have pretty much a hair trigger takedown rule, which is the moment somebody complains, then they take it down. Now, that's if there's no Section 230. You can imagine variants of Section 230 that set up some sort of intermediate rule. But
would a judge have handled this if there was no Section 230? That had been my view, that a common law, rational judge would have understood that there is such a thing as a platform versus a speaker.
So the answer is that judges did handle it, and they handled it in opposite directions. So Section 230 was specifically response to two decisions, both by trial level judges. One said, I believe it was CompuServe, was not liable for things posted on it. And another, which involved Prodigy, remember those? They used to be big back then. Involved Prodigy, that was also kind of a CompuServe-like platform that would be potentially liable, at least once they were on notice that something supposedly defamatory. Now, the Prodigy judge actually tried to draw this line that some people are calling for now. They said, look, CompuServe was a free-for-all, anything goes. It didn't edit things at all. Whereas Prodigy does edit things, and I think it's like supposedly blocked pornography and profanity and such. And therefore, because they've decided to provide this kind of filtering, then they lose this immunity. So that's specifically the rule that Section 230 deliberately rejected. And why? Part of the reason was that many members of the public liked the idea of having platforms that are filtered in some ways. This is before the spam explosion, but surely that's one thing we all want in a platform, is to get rid of spam. But also some of them like the idea of having platforms that block vulgarities or block pornography because they wanted a place that's more comfortable for them, maybe more comfortable for their children. So under this rule that those two judges set up, and of course that was just what those two judges came up with. It would have taken decades for a clearer rule to emerge over time as it went up on appeal. And remember, we have 50 states, and it may be different in different jurisdictions. But in any event, under the rule that seemed to emerge at the time, there's this strong disincentive to editing. And not just strong disincentive to what one might think is unfair, politically prejudiced editing, strong disincentive to any editing. Again, under those decisions, it looked like attempts to block spam, under the Prodigy decision, would have stripped the platform of its immunity. Likewise, on our blog, we have comments. There are the comments in Parler, but with regard to our headlines, but the real conversation, generally speaking, happens on the blog because there are longer comments that are response to the whole blog post. I generally don't delete comments, but I do delete spam. I tend to delete personal insults. I delete vulgarities. Vulgarity, not just specific vulgar words, but when somebody's like trying to sexualize some discussion in a vulgar way, because I'm trying to create a helpful conversation. And I think those things are poisonous to conversation. So Section 230 allows me to do that without, it gives me this immunity and it doesn't strip it from me when I do the editing. But in any event, that's the first part of Section 230, the really important one, protection against defamation lawsuits against platforms, invasion of privacy lawsuits and the like. Again, things that without which probably Parler could not exist. There's the second part of Section 230, which also says that platforms are immune from lawsuits for deciding to remove material that is violent or harassing or otherwise objectionable.
Yes.
But this is the much less important part of Section 230. Why do I say that? Because while the first part, absent Section 230, it would have been very different and Parler might not even exist. The second part, absent Section 230, there would be almost never a basis for a lawsuit against a platform for deleting material. Because refusing to let you post what you want to post on my property is generally not a tort. Allowing you to post something that may damage somebody else's reputation through falsehood may very well be a tort, often is a tort with a lot of money at stake. But if I just were to say, let's say, absent Section 230, I did have comments, and then I just deleted some comment, somebody sued me, I'd say, what are you suing me for, right? Not for defamation, I just deleted your comment. You could say, I'm suing, that you're suing me for violating your free speech rights, but you have no free speech rights.
Censorship, exactly. They always say censorship. Yeah.
Right, but there's no tort of censorship. You have no right to speak on my platform. I don't mean that as just some abstract libertarian matter. You could debate about whether there should or shouldn't be a right to speak on certain kinds of platforms. But just as a matter of existing common laws, existing statutes, generally speaking, people don't have a right to speak on other people's platforms. Now, were it not for the second part of Section 230 that immunizes these kinds of editing decisions, there might be some common law and statutory development. So occasionally you hear people make claims, well, you deleted my comment because you're discriminating based on religion, and you should be viewed as a place of public accommodation, and you shouldn't be allowed to discriminate based on religion. And there are these state public accommodation laws that ban discrimination based on religion. And then the question is, do they apply to discrimination based on the message or only discrimination based on the identity of the poster? So you can imagine those claims. Occasionally they're brought, they're thrown out under Section 230. But even if the second part of Section 230, the protection for the decision to edit, were removed, those claims would be pretty rare. And incidentally, they might be preempted by the Commerce Clause because they're all state law claims. And there are real constitutional barriers to state laws, state courts, or even federal courts applying state laws to this fundamentally interstate, in fact, international medium of the internet. So that's why the second part of Section 230, this protection for editing decisions, that mostly restates existing law. The first part very substantially changed existing law. The second part mostly restates existing law. So if you want, whether you do or should want, protection against private censorship on Twitter and Facebook and such, it's not enough for you to repeal that part of Section 230. What you'd need to do is you'd need to provide some sort of affirmative claim. Either provide some sort of affirmative claim, oh, there's a new statute, new federal statute that says Facebook and Twitter cannot delete these posts based on their message or something like that. And then you'd have to distinguish between that and deletion of spam and various other matters. Or you'd have to say, well, the first part of Section 230 is only available to the non-editing platforms. And then we deny this protection against liability to the editing platforms. And again, then you'd have to figure out, like, what do you do with platforms that edit in order to remove spam and edit in order to maintain, again, kind of helpful conversation in spaces where conversation is something they're trying to promote.
Okay. Well, thank you for that. And you used the phrase private censorship. Is that your answer to the fact that, in effect, in conversations out there, the word censorship has become vague or misleading in a lot of contexts? Are you using private censorship as your phrase?
Most words are vague. Few words are not. 17, that's a pretty clear word. But most words are vague. So for example, freedom of speech. Freedom of speech refers to a legal principle. And in America, this legal principle is that it's freedom, generally speaking, I oversimplify here, but freedom from speech restrictions by the government. But it also could refer to a social convention. And one particularly clear example is in Harvard, let's say, to take an example of a university that's unambiguously private, but has long been thought of as a place that does not market itself as wedded to some particular ideology, is not, for example, a religious university that may frankly say we are about promoting our religious faith. Not all religious universities are that way, but some might be. If, for example, Harvard said we're going to expel any student who says things that are unpatriotic, then we might say that's a violation of freedom of speech principles. It's not illegal. It's not unconstitutional. Maybe it should be their right as property owners to do that, but it's a violation of freedom of speech principles. So likewise with censorship. Censorship clearly does refer to certain kinds of practices by the government. Traditionally, it had referred to very particular kind of practices having to do with pre-screening of material. So maybe if you are being prosecuted for advocating draft resistance, maybe that's not even technically censorship under some definitions, because that doesn't involve pre-screening, but only punishment after publication. Maybe. Increasingly, it had ended up applying, and probably applied even at the outset, to also things that involved after the fact punishment, because ultimately it's not really that different from pre-screening systems. But also another way of understanding the word censorship is usually used to refer to speech restrictions imposed by institutions that one views as having some obligation to protect free speech. It could be an obligation that is imposed by law. It could be an obligation imposed by contract. Maybe they promise to protect free speech. Or it could be an obligation imposed by social norms of some sort or another. Is that imprecise? You bet it's imprecise. I would not accept that in a legal brief, some other person just says the defendant is censoring me. I'd say that's not anywhere near enough to explain what the legal problem is. But as a rough cut meaning for that term, with the understanding that you then have to explain why it's improper for speech restrictions to be exercised this way, I think it's plausible. I mean, just to give an example of where it's not plausible, imagine somebody were to say, the newspaper is censoring me by not publishing this op-ed that I submitted to them.
Yes.
Well, they kind of have to pick and choose, right? There are only so many pages out there, but also only so much attention span on the part of their readers. In fact, their readers subscribe to it precisely because of their editorial judgment. If the newspaper published absolutely everything, it would be useless to the readers, right? So there it doesn't make much sense to say they're censoring. But when it comes to institutions that do provide something of a broad public forum, not in the legal sense, but in the common sense, of a place where people can generally speak, where there's not as much competition for a narrow range of column inches, let's say, then you might say, well, this is an institution, especially if it's one that's billed itself as a platform for free debate, that when it restricts it in a way that we think unfair, we might call it censorship.
Okay. So thank you. That is clarifying, and coming from a First Amendment scholar, of course, authoritative in a big sense. And for us at Parler, where we explicitly talk about our guidelines being written in the spirit of the First Amendment of the United States Constitution, then we are taking upon ourselves an obligation to give our users the freedom of expression. But let's go on to the proposed amendment to Section 230 that I wanted to talk to you about today, which is the one that has been proposed by Marsha Blackburn. It is the so-called Online Freedom and Viewpoint Diversity Act. And I think you've already answered one question that I had with respect to it, because one of the things that this act purports to do is to affect that second function of Section 230 that you described earlier, namely when it excludes liability for taking down certain types of content, it attempts to narrow, not completely obliterate that whole part of Section 230, but narrow the range for which that immunity from liability
Right.
exists. Yeah.
Right. So I think there are two things that are worth saying about this. One is that it narrows the immunity for editing, let's call it editing decisions or removal decisions. But it doesn't create an affirmative cause of action
Right.
for removal decisions. So even absent that immunity, again, if somebody says to Twitter, you deleted my post because your view was transphobic, and I think you're just being viewpoint discriminatory, I'm going to sue you. Twitter's response is for what? And if the plaintiff says for violating Section 230, Twitter says, wait a minute, Section 230 imposes no obligation on us. It gives us certain immunity. We are going to, so we may not have immunity from a state law cause of action for your lawsuit, but tell us what's your state law cause of action. It's not, as I said, defamation. It's not breach of contract because, well, there's some debate about it. Generally speaking, the terms of use make clear that this is the platform's property and gets to decide what is posted there and what's not. It's not censorship because, again, whatever censorship is, it's not the name of a tort. It's hard to see what the basis for that lawsuit will be. So that's one thing. And maybe that means this bill is not particularly harmful in that respect if you think that this ability to edit is useful. That is to say, platforms' ability to remove things is useful and helpful to public debate and helpful to consumers. But is also not something that's going to solve the problem if you think it is a problem of discrimination by platforms. Again, it might increase the number of, say, anti-discrimination claims brought on the theory that there's discrimination based on race or religion or sex in deleting certain comments, or sexual orientation in those states that provide, probably in all states now, given the court's recent decisions. In a few jurisdictions, DC is one of them, Seattle is another, ban discrimination in public accommodations based on political affiliation. Some of them limited to party membership. So maybe then there could be lawsuits that they say you're banning speech by Republicans, but not by Democrats. But those will be, again, dicey lawsuits because there probably shouldn't be state law rules applicable this way to platforms, given that a platform would then have to figure out how to comply with 50 plus different rules. So that's one thing. Just keep in mind that this does not actually give anyone the right to sue. Here's the second problem. Remember, we were talking about how these days people expect there to be certain kinds of removal decisions as to spam, maybe as to personal insults, various kinds of things. And one thing in particular that a lot of platforms have been doing with encouragement from the government, but also I think they've agreed this is a good idea, is to remove pro-terrorist material. Well, if you ban them from engaging in viewpoint discrimination, they can't remove pro-terrorist material. So this bill tries to solve that problem by specifically exempting from its limitation of immunity. So in other words, specifically allowing platforms to remove speech that promotes self-harm or promotes terrorism. But this, I think, makes this law viewpoint-based. It's not a viewpoint-based speech restriction because, again, it doesn't restrict any speech. But it's a viewpoint-based enabling of certain kinds of private speech restrictions. So platforms would still maintain their immunity if the speech that they exclude based on viewpoint is pro-terrorist or pro-self-harm. But if they remove other kinds of speech, anti-terrorist, anti-harm, or other kinds of things, then they lose that immunity. Now, it's not open and shut, but there's a very good argument that the government, Congress, can't discriminate based on viewpoint when it provides immunities like this. Can't discriminate based on viewpoint when it restricts speech, but it can't discriminate based on viewpoint when it provides immunities from speech. One classic example is, imagine there was an immunity for patriotic speech, but not unpatriotic speech. That would quite clearly be unconstitutional. At least I think it would be clearly unconstitutional. But I don't think that there is, as a First Amendment matter, a different rule when the law, as this proposal would, has a special provision for speech that promotes self-harm or promotes terrorism. That's still a viewpoint discrimination that I suspect courts would say Congress cannot engage in.
Okay, so that was something that I did not expect to see that as viewpoint discriminative, because I see those sorts of speech as I mean, I guess self-harm is hard to characterize this way, but as pro-violation of rights in terms of initiation of physical force. And
well, as a moral matter, as a moral libertarian matter, that might make sense, although then the question is, why is it limited to terrorism? But as a First Amendment matter, the Supreme Court has long said that even advocacy of unlawful violence is often constitutionally protected, in part because often a lot of speech that has legitimate calls for legal change and legitimate calls for condemnations of the existing order can be seen and is often seen by its critics as implicitly or even explicitly promoting violence. But in any event, that's the backstory to why the First Amendment protects even speech that promotes terrorism and promotes self-harm and promotes other violence. The bottom line is it does protect that. So then the question is, can the Congress say, well, we're going to shield a wide range of constitutionally protected speech from private suppression, but we're not going to shield certain viewpoints that are constitutionally protected from private suppression. I doubt that. I think that's unconstitutionally viewpoint based.
okay, so there could be a challenge to it in addition to the fact that it wouldn't create a private right of action, and also it could be subject to a constitutional challenge, both of those things. Although I guess you would say it's not a private right of action, it is a challenge, which is basically all people need to get in court. But it's not the constituency that wants to hold them accountable that would have a right of action. These are different constituents, right?
Right, exactly. So somebody who says Twitter banned my or deleted my, or let's say removed my account or deleted my tweet because of my viewpoint, they wouldn't be able to sue under Section 230. However, somebody who says, well, wait a minute, this statute is protecting other people's viewpoints, but not my viewpoints, they probably could sue under general kind of federal jurisdiction over alleged violations of constitutional rights by government entities, because the lawsuit would be claiming that it's the government that's engaging in viewpoint discrimination by selectively shielding certain kinds of speech, but not other speech from private restriction.
Okay. So that's one part of this proposed amendment to Section 230. Again, it's called the Online Freedom and Viewpoint Discrimination Act, and it's been put forward by Marsha Blackburn and others. The other section of it, as I understand it, addresses that first function of Section 230 that you were talking about, distinguishing between a platform, as they call it, editorializing versus formatting content, somehow making it look nice and not addressing the substantive nature of the content, right?
Well, so yes, although it's not clear that this would actually change the law, change the current legal rules. Yes, so subsection 2 of the bill would provide that a platform is liable if it editorializes or affirmatively and substantively modifies the content of another person or entity. Now, I think that is largely already the law under Section 230 now. So Section 230 protects me from liability for the speech of my commenters, but it doesn't protect me from the liability of my own speech. So if, for example, I update my post to say, this commenter says that he saw Amy Peikoff dipping into the petty cash. And I say afterwards, and yeah, that sounds exactly right to me, I would be liable to you for defamation, assuming you're not dipping in petty cash. I'm sure you're not. I'd be liable to you for defamation.
Who has petty cash in COVID? I don't know, but yeah.
A very good point. I'd be liable to you for defamation, at least potentially, not for the comment, but for my own speech, for my own editorializing. So I don't think this editorializes affects things much. Now, what if I affirmatively and substantively modify the content of a comment? So let's say the comment says, I saw Jane Smith dipping in the petty cash. And I say, I'm just going to change that comment to say, I saw Amy Peikoff. And then you figure out that's what I did. Well, then in that case, I would already be liable because, again, I'd be liable for what I said and not for what the commenter said.
Right.
So it's not clear to me that this new subsection 2 of the bill would really affect things much. It may clarify things in some measure, which, you know, I don't think it's bad, but I don't think that it would be a substantial change. Now, there's
what about the thing that inspired it, the putting the flag or some sort of fact-checking flag on President Trump's tweets?
Oh, well, certainly, if I take one of your comments and put around it saying, this is a dirty lie.
Yes.
Amy just made it up.
That's how you would do it, right? Twitter has this, oh, we have this committee of fact checkers and blah, blah, blah. Eugene says, no, on my blog, it's, this is a dirty lie. Yeah.
Well, I'm trying to make the clearest example because that is clear factual assertion that this statement is factually false.
Right.
And is in fact knowingly false, a lie. And you could sue me on the grounds that I'm defaming you by calling you a liar. And not just in general a liar, but saying you lied as to this particular statement. You can already do that. Now, on the other hand, what if I post as a comment something that says, you know, that comment just before mine, I gotta say, I'm skeptical about it. And other people who are really serious, have seriously looked into this, have concluded that it's not true. Already, you could sue me for libel. Nothing in Section 230 precludes you from suing me for libel in that kind of situation. It's just that I'd have some pretty good defenses. Some situations I might have an opinion defense saying, you know, I just think that this doesn't seem plausible given the facts that I know. Mm-hmm. That could be opinion. Or I could have a defense that I am reasonably relying on the judgment of reputable organizations. They say it's false. I'm allowing you to present your viewpoint. I'm allowing them to present their viewpoint. And therefore, I just have a substantive defense against the libel claim, which is that I reasonably believed that the statement that I was posting was true. That statement was that what you said was false. So again, I don't think that it's Section 230 that's getting in the way of that kind of lawsuit. You can imagine a few situations in which Section 230 might get in the way of that. So maybe this will change a few scenarios. But the standard fact checking, no, I don't think so. Already, if I fact check something and in the process of fact checking, make a factually false accusation about the person that I'm fact checking. I claim he's lying, or I claim that he's incompetent, or whatever else, potentially I could be sued. It's just that I often have a lot of good defenses against it, such as I'm relying on the work of reputable organizations.
Right, right. But from a practical standpoint, it could result in more litigation, which could be more expense for social media platforms. And those are expenses which an established large platform with a lot of money like Facebook could better handle than, for instance, someone like Parler, right?
Right, it's true. It's true. Yeah, I doubt that it would increase the amount of litigation much, but it might just by kind of making lawyers think that there's some new arrow in their quiver. But yeah, this is one argument that many have made, and I think with some plausibility, about the calls to impose more fact-checking obligations, for example, on platforms, or more editing obligations. That maybe Facebook and Twitter could do very heavy fact-checking and editing because they've got a lot of money, or at least Facebook and Google have a lot of money. But upstart rivals to them might find it much harder to comply with a lot of these obligations. So in that respect, Section 230, while it's a huge boon to the existing platforms, maybe even comparatively more of a boon to new platforms, because the existing platforms, now that they've benefited from Section 230, have a lot of money that they could use in order to deal with new requirements that are imposed on them, because Section 230 is relaxed or is weakened. Whereas new platforms don't. I mean, if somebody were to tell me, look, I'm going to be liable for any libels, any defamation in my comments, unless I promptly remove it, I'll probably say, you know, I've got to turn off the comments because too much work for a shoestring operation like mine.
Exactly. And that's the thing. I mean, you don't have the budget. We wouldn't have the budget if that burden was placed upon us. And that's why I think Mark Zuckerberg has repeatedly before Congress basically asked to be told that he should regulate or, you know, moderate for hate speech on his platform. That is something that the government couldn't do directly. But he seems like he would welcome it. He's bragged about having the AI to regulate hate speech on Facebook. And that is something that you and I wouldn't be able to do either in your comments or in the comments on Parler. Yeah.
Right. I mean, to be fair, I don't know. I haven't followed all of his testimony, but I don't know how much he actually wants Facebook to be required to regulate hate speech. But I could certainly see somebody in his shoes saying, look, I don't want to be constantly pressured to try to do this in some informal ways, in part because then they're just pressuring me and not pressuring my competitors. If you do want me to do this, set up a rule that applies equally to everybody. And if you don't set up a rule that applies equally to everybody, then stop bugging me. I don't know if that is exactly his position, but that is, I think, one way of understanding that, and that's a legitimate thing for a business to do, to want to make sure that it's subject to the same constraints as other businesses, but as its competitors. But of course, at the same time, or excuse me, vice versa, to make sure its competitors are subject to the same constraints. But of course, it may be that for Facebook, those constraints are less burdensome relative to its bank account than they would be for a Parler or for a Volokh conspiracy.
Yeah, that's what it sounds like. Definitely. One more question, if you have time, Eugene.
Of course,
I like to stick to an hour.
Time for you.
We thank you so much. Well, this is actually for a Parler user. We have James in the D who sent a question to you via Parler. He says, please ask the professor. Alexander Hamilton wrote in the Federalist Papers number 78 that judiciary has powers neither of will nor force, but merely judgment. We have seen since early in our US history that federal judges too often exercise will in place of legislators. An example is the recent federal judge in Wisconsin who decided mail-in ballots can be counted up to 5 days after the election despite state law. What remedies can be considered or recommended other than appeal, too slow, he has in paren, or impeachment, impractical, he thinks?
Well, so this has been a problem that's existed throughout American history and probably before American history as well. We like the idea of judges just following the law. But the reality is, in Anglo-American history, judges have created the law. When we talk about the common law, that's judge-made law. Now, it has been made through a particular process that's multi-centered, that judge here, judge there. It's been rarely, although sometimes, but rarely, one judge does it all, or even a few judges do it all. It's something that aggregates over time. It changes relatively slowly. It is influenced quite heavily by the mores of the community. But it was judge-made law that is based on will. Just to give an example, there used to be a tort of alienation of affections, which meant that if somebody seduced my wife, then I could sue not her, but him for alienating her affections. Mm-hmm. And the tort still remains in a few states. North Carolina is the most prominent one, often litigated there. It's sex neutral now. So half the cases I've seen brought by women against usually other women who seduce their husbands. And it was recognized by a lot of judges, but it was judges who made it. And then it was repealed, often by legislatures, but sometimes by judges as well, who said, look, other judges made it because they thought that was consistent with sound legal principles. Other judges can unmake it. So one reality is that this is the way our system has long operated. We have not had a system where everything has to come from the legislature. As I understand the European legal system, is generally understood as being requiring detailed codes set forth by the legislature. But that's not been the rule in many areas of Anglo-American law, for better or worse. The other problem is we have this habit of setting up statutes, but also especially constitutions that are not very precise. Yes. We don't say, here is this 20-page document about speech and what speech is protected and what speech is not. We say Congress shall make no law abridging the freedom of speech or of the press. Okay, what does that mean? Well, you could try to figure that out a little bit by looking at history, but the history is often ambiguous and often doesn't respond to particular questions, and yet judges have to apply the rule, right? The 14th Amendment doesn't say there shall be no discrimination based on race or religion. It says no state shall deny to any person the equal protection of the laws. What exactly does that mean? Is it only race discrimination? What about sex discrimination? What about other kinds of discrimination? Is it saying no race discrimination, period? Or does some race discrimination not deny equal protection of the laws? Again, right or wrongly, that is the way we've organized our legal system. And we can't be surprised at that point that judges say, well, equal protection. Let me tell you what I think equal protection means. Let me tell you what I think due process means. Now, some people think that the solution to that is look to the original meaning. And maybe that provides something of a constraint. But again, original meaning is often hard to piece together. We have to acknowledge there are real limitations in trying to figure this out, especially when the debates of the time are not perfectly recorded. And to the extent they're recorded, they dealt with a very different set of issues. So it's true that the judiciary does not have force the same way that the president has force. I mean, there are bailiffs and such, but effectively they count on the executive to enforce their judgments. Yes. But it's true that they do have will and they do exercise it. And that's the reality. And what do you do about it? Again, one possibility is just say, let's just make sure that all of our statutes are as clearly and precisely defined as possible. I'll give you another example. Copyright has this fair use doctrine. Just created by judges that say not every copying is an infringement. Copying for parody or for criticism is not an infringement. Copying for certain personal uses is not an infringement. That was all created by judges, contrary to the literal text of the Copyright Act. 1976 Act, Congress codified it, but there it codified it saying they shall consider factors including, and then the 4 factors that the judges themselves had identified, but left open to judges to consider other factors and told them to balance these 4 factors. What is balancing? Demand the judges balance other than a call for them to exercise their will. So we can stop that. We can say from now on, we have very carefully detailed codes. One familiar problem with carefully detailed codes is even if you write them in very great detail, there are going to be things on which they're going to be ambiguous, going to be things which they were not anticipated, and they become much harder to remember. Even if they're theoretically precise, it's much harder for people to understand, to remember and understand and incorporate into their understanding of the law. So you could say judges must be originalists, but again, that's not easy to do. Plus, for whatever it's worth, even on the Supreme Court, even among conservatives, that hasn't gotten unanimous approval. Most justices consider original meaning in some measure, but in terms of hardcore originalists, there's Thomas probably, Scalia mostly, Gorsuch maybe, but at any one time there are only 2 of the 5 conservative justices who are really even committed to that. So I appreciate the problem, but I'm not sure I see the solution. Or rather, we see some solutions, but for whatever reason, they are either politically unavailable. There's no political will to implement them, or they are practically quite difficult to arrange, such as the writing of comprehensive codes. So it's a really serious issue, but I just don't see a simple, clear, straightforward answer to it.
Yeah, I mean, statutes and constitutional provisions are written in words. And as we talked about earlier with the word censorship, each word needs to be discussed as to what its meaning, what its proper reference in the world are. And our knowledge expands over time as well. It's not just new
Right.
cases.
So there's a great line that I want to just look up because I want to get it exactly right. But if I don't get it exactly right, at least I remember the approximation. And this is actually from Justice Marshall, Thurgood Marshall. That, let me just see if I can find it. Well, I can't, but it basically is condemned to the use of words. We cannot expect mathematical precision from our laws. And I like it, condemned to the use of words. That is the state of humanity.
Well, I wouldn't look at it as condemned, but condemned, it would be a philosophical judgment that we could talk about another day. But what I want to let you do before I let you go is please plug whatever you would like to plug. What are you working on? What do you have going that you would like to tell Parler users about so that they can see more of your work and your brilliance?
Well, very kind of you to say so and to offer the opportunity. I've got a bunch of things happening. Some of them are law review articles that I don't think people really want to read. But I do think that our blog, both kind of the headline version on Parler and the full posts that are linked to from the Parler headlines and that are available at reason.com/Volokh, is a good place to start. If I really am thinking about something I think is interesting, I'm going to blog about it. But then on top of it, it's not just me. Because, you know, I'm sure people like Parler users like some of the things that I like issues about free speech, issues about academic freedom, about gun rights and such. But your interests are much broader than my purely academic interests in my area of specialty. So we've got people writing about criminal law and criminal procedure like Warren Kerr. We've got people writing about the controversies having to do with the replacement for Justice Ginsburg. Josh Blackman has been writing a lot about that, and others as well. So check out our blog. I think you'll find it very interesting.
I loved speaking with Ilya Soman earlier this year about foot voting, migration issues.
Oh yes, absolutely.
In his new book.
Yes. Ilya writes about that. And note again, he writes mostly, not only, but mostly about things he's a real scholar on, one of the leading specialists in the subject. And that's one of the advantages of blogging compared to the old mainstream media and newspaper world, that we try to make our things accessible to the public, but we come from a real knowledge base on things that we've studied closely and some of which we've actually provided the original research for. So if you like that sort of thing, blogs are pretty much the way to get them.
Excellent. Thank you very much for giving me your time today, Eugene. On behalf of Parler users, I thank you too. And we look forward to seeing your content over at Parler, interacting with it and learning
Excellent.
more. Thank you.
Excellent. Thank you. And all the best.
Have a good afternoon to you as well.
You too.
Okay, everybody. Thank you. I'm out of here. I guess I could look and do a quick scan on Parler one more time. I've been refreshing throughout while Eugene was talking, trying to do it subtly to see if I had missed any questions, but as far as I know, I did not. And I know that that's a comment. I have 2 posts over here at Parler. Let me check. Nope, it looks like it's the same number. Okay, so thanks everyone. Thanks for joining me, and you'll see me around. I'm hoping to interview more interesting people that I have encouraged to get involved or get more involved in Parler as time goes on. Eugene, I've known him for decades, and so I was very happy to share that value with you. As you see, he's quite knowledgeable, quite fun, quite value oriented. One of my favorites. Okay, take care, everybody.